constitutional lawyer. I've been a litigator and a lawyer for 38 years, and I've been practicing in the highest levels of the federal courts. My concern here is as a lawyer and as a litigator, and I think this bill is misnamed. The bill is really not the Firearms Safety Act of 2013. It's the Legal Nightmare for Gun Owners Act of 2013. This bill is rife with legal traps for the unwary. And it's almost designed to be a situation where persons who are caught up in this, otherwise law-abiding citizens who obey the law as a matter of course every day, are caught up in a situation where they simply don't know that they're violating the law. And the penalties are so severe that will loss of their liberty, but also loss of every firearm they have, regardless of whether or not they are in fact actually put into jail. And I'll give you one example, which is near and dear to my heart. I have a 19-year-old son. He is legally able to purchase a long gun in this state under both federal and state law. A shotgun, a hunting rifle, he hunts with me. He's an excellent and very safe hunter. Under this bill, he is legally prohibited from possessing a single round of any type of ammunition. A .22 rimfire, a shotgun shell, doesn't matter. And the bill does this through a surreptitious amendment to 5-133D by deleting the portion of the bill that restricts the age restriction to ammunition designed solely for regulated firearms, and then adds 5-133.1 to broadly define firearms, and then ban the possession of firearms for all persons who may not possess regulated firearms. And if you look back at 5-133, you will see that one of those bans is on persons under the age of 21. Now, I have submitted written testimonies, 12 pages, single space. I commend it to you. It details all this in painful detail. It's a legal brief, if you will. But this would bar my son, who in 2 years will graduate from VMI and probably be commissioned as a second lieutenant Marine, from possessing a single round of ammunition when he comes home from school. It will bar him from hunting. It will bar him from trap shooting or target practice. He will be able to actually purchase a long gun, but the moment he takes possession of ammunition for that very legal long gun that he possesses, he will be subject to a year in prison. That's not right. And the list goes on as to other legal traps for the unwary.
I know you want to tell us what you got, but
I understand,
right.
And I thank you for your time.
Oh, you've got some people who
Oh,
want
good. I would like to answer questions.
Senator Shank first.
Okay. Thank you very much. And I have read your testimony, and I'm still trying to wrap my head around this provision, so I'm going to need a little bit more help on that.
You bet.
So anyway, but towards that issue, let me move to something, because for a variety of reasons that we've heard today and some that we'll hear later, I am very concerned about this aspect of the otherwise law-abiding citizen who you just referred to, who's going to get caught up in this. And I think this committee has genuinely been concerned about that in a variety of different issues. And the fact that there is no mens rea in here is deeply concerning to me. Is there a fix to that provision? If we were to say knowingly and willingly violated the provisions of that, is there anything that can fix that, in your opinion, within the confines of this bill?
The ban on ammunition possession by a person under 21, I don't see how there is a fix. You don't need it, for one. You have an existing law under 5-133D2 that says that an under 21-year-old may not possess ammunition designed solely for regulated firearms. Why do you need to ban any possession of ammunition? The Sienta requirement that you're referring to just raises the disputed issue of fact. It's not going to protect him from arrest. If my son is arrested, there goes his Marine commission. It doesn't matter if he's convicted.
It's just the arrest itself.
Just the arrest will do. He will be forced to defend himself in court, attorney's fees and costs, not to mention the legal trauma that goes with that. You have a similar situation with the registration requirements, a 30-day window. On the 31st day, you're a criminal. Doesn't matter if you simply didn't know. There's no provision for a late registration. If you have that, you may have been out of the town, you may have been out of the country, you may have been on wherever. It's an innocent failure to register, criminal. 3 years in jail. And because it's in excess of 2 years, you automatically employ, if upon conviction, a federal firearms disability under 18 U.S.C. 922G. All his firearms are gone for an innocent failure to register a so-called assault weapon. That's insane to me.
So towards that point, I agree with most of what you have said and most of what the opponents to the bill have said. But moving forward in terms of looking at within the confines of this bill, again, I hear you in saying you can't put knowingly and willingly in. What is a reasonable balance in terms of if the committee is to move forward on any type of registration, which I don't know whether we would or not, do you make it a civil fine? I mean, obviously the state has the ability and should have the ability to say, okay, we want you to do X, Y, and Z, and if you don't, there's going to be consequences for it. Is there something in here that is more acceptable, or, again, it's just the whole thing?
Senator, are you talking about the ammunition ban?
I'm talking about the ammunition ban. I'm talking about the failure to register if it's a handgun, and then I'm talking about the other criminal provision which I've caught in here, which is the failure to register the so-called assault weapons.
Well, and there's other provisions too. If you read my legal brief, if you will, the required and intent requirement is really not going to fix the problem. It's simply the police officer is going to look at you and say, well, you're intending what you're doing, so you're under arrest. So that's the interim effect that will keep the people basically under the thumb from trying to go. It will keep me out, and I know the law. And I don't want to take any chances with that. I have a security clearance. If I'm arrested, I lose my security clearance. What you have to figure out is whether or not what you're doing here is addressing the problem at hand, which is the illegal use of handguns, not by law-abiding citizens. Now, I've heard testimony today about, for example, that you need the registration period for a prior registration period and licensing of handgun owners. Now, I own handguns. I own several. Because you need to stop straw purchases. Well, as a matter of constitutional law, that is a burden. This licensing provision, all of that, including the hundreds of dollars of cost and perhaps months of delay, is a direct burden on the constitutional right to purchase the handgun. And you're going to have to justify that in court, and you're not entitled to a rational basis test on this. You're going to have to do at least intermediate scrutiny, which means you're going to have to show with actual evidence that this registration, this prior licensing provision, will in fact meet the problem you're saying it's going to meet. Conjecture's not going to cut it. The idea that a straw purchaser, to me, it doesn't make any sense that a person who's willing to fill out Form 77 and Form 4473, federal and state forms under penalty of perjury with felony penalties associated with them, would be in the slightest bit deterred from doing the same straw purchaser by having to go to the state police barracks and having fingerprinted. They don't care. Criminals don't care. And that is the point. They're going to do a straw purchase, they will do it regardless. But what you're doing in the process of trying to stop a straw purchase that you can't even be sure that it's going to be stopped is you're going to be substantially burdened with high costs and long delays, the very fundamental right that Keller affirmed to every citizen in this room. And
I think you have another question with Senator Jacobs, if you don't mind.
Yes, I'm sorry.
Oh, that's okay. Earlier when I mentioned to the governor's people that I would become a criminal if I did not go back and register my firearms before October 31st. They said that was not true.
Oh, you would?
I know I would.
You would
I have
indeed.
Attorney General's opinion here that says I would. So on October 31st, everybody in this room who owns a firearm, if they don't get their butts down there and register them, they're criminals.
That's a regulated firearm, Senator.
I'm sorry.
But yes,
My
in
assault
fact,
weapon.
if your so-called assault weapon, I mean,
Yes.
A rifle, if you will, the rifle that hardly causes any crime, you would indeed, because there's no provision in this bill that allows you to register on the 31st day. Because on that 31st day, the mere possession of that rifle, and there's a no intent requirement, becomes a criminal act punishable by 3 years in prison. The very provision that used to apply only to assault pistols, a very narrow class, has now been expanded to guns that were legally purchased, legally possessed, and legally used up to that 31st day. That's wrong. You are criminalizing people who are tax-paying, productive citizens who live their lives in accordance with law. It penalizes everyone. And I don't even own an assault weapon, but it's still wrong.
So-called.
Chairman, committee members, thank you for making this accommodation and thank you for the opportunity tonight. I'm here today, all day, to present testimony in opposition to this bill for a number of reasons. On behalf of the thousands of gun owners in Frederick County and also the 230,000 residents of Frederick County who I'm responsible for upholding their constitutional rights. I think this bill in itself, on the face, does a lot to infringe on their Second Amendment rights and also is an assault on their rights in many ways. This bill, if you look at it on the surface also, if you look really closely, I think you're going to see it's in direct conflict with the Declaration of Rights of the State of Maryland if you look at Articles 2, Article 28, and Article 44. Another constitutional issue that I think could be very arguable, when you look at the bill down the line, in effect what it does, it bans future ownership, potentially. It only allows you with certain limitations to pass on or hand down the firearm to family members. I think that effectively constitutes a taking or a seizure of your personal property under both the Fifth and the Fourth Amendments of the Constitution. So I think you should really look closely at that. What this bill does, it bans certain types of firearms strictly on the cosmetic or the appearance of the gun, all in response to emotional and politicized misinformation out there. It mandates expensive training for current legal gun owners, knowing full well that no one has access to this training. It's just not out there. It's not available. It criminalizes the currently legal regulated firearms owners who are otherwise law-abiding citizens. And what this bill is going to do is create a tremendous burden on law enforcement, which is already overburdened, understaffed. Senator, you made a comment about the state police doing more and more out of the barrack. I'm here to tell you they don't have the manpower to do that, at least not in Frederick County. What this bill won't do certainly will not keep these firearms out of the hands of criminals intent on doing harm or committing violent crimes. It's proven that gun laws just don't do that. Certainly will not deter acts of violence, and it really doesn't do anything to promote the personal protection rights of citizens. What I'm finding right now is when I'm talking with my citizens in Frederick County, this bill has done nothing but created fear, emotion. There's now a panic that we can't get these guns, we can't have these guns. You can't find a bullet in Frederick County. And that's all because, a lot because of this bill, a lot because of federal law. I think there are some, let me mention this. There are currently in 2012, a total of 69,600 applications for regulated firearm purchases. That's a 66% increase over 2011. Why? It's driven by this panic and hysteria. I think there are some effective measures that can be taken. Most of them could be amended in the current laws. I think you strengthen and tighten the background checks to include complete access to juvenile records of violent offenders. I think you assure local court records a check for domestic violence and civil protective orders for denials. You restrict the gun ownership to persons with who suffer from identifiable mental illnesses, like we've talked about, others have talked about tonight. This is the one commonality in all these violent acts, I think, if you look at it. Most importantly, you provide the tools, the funding, the resources necessary to law enforcement to enforce the laws that are already on the books. If you do that, that goes a long way in getting where we need to go. Most importantly, allow Marylanders the right to defend themselves. Folks, law enforcement cannot protect the individual. I can't protect my citizens. Worst of all, I guess as I close, I'll say this. I hope if you take one thing from this testimony tonight, you take this. This is a very deep, emotional issue with individuals, the right to defend their families, the right to have access to whatever firearm within reason. I don't think semi-automatic rifles are unreasonable. My worst fear as a sheriff of Frederick County is that good people may die in trying to confiscate and seize these firearms. Good people may die in trying to hold on to their firearms. That's what I'm afraid of. So whatever the outcome, I think it's in your hands tonight, and I would urge you to kill the bill. And again, I don't think it's going to have any impact at all on violent crime.
My name is Henson Ong. Forgive me, English is not my first language. I am a legal immigrant, and I am an American by choice. Thank you for giving me this opportunity to express my opinion and give my testimony in opposition to the majority of the proposed bills which do nothing to deter future crimes. Gun control does not work. Your own history is replete with high school rifle teams, Boy Scout, marksmanship merit badges. You could buy rifles at the hardware stores. You could order them, mail order, delivered to your home. Your country was awash in readily available firearms and ammunition. And yet, in your past, you did not have mass school shootings. Other people have already expressed the question, what changed? It was not that the availability of guns suddenly exploded or increased. It actually was decreased. What was changed was societal decay. If gun control actually did work, Washington, D.C. and Chicago would be the safest cities in your nation, but it is not. They have the toughest gun laws and the highest crime and murder rates. Now, some people have asked and called the AR-15. They called the AR-15 a weapon of mass killing. Well, it turns out that there are a few government agencies which disagree with that characterization. The Department of Homeland Security has stated that a rifle chambered in .556 NATO with a 30-round magazine is suitable for personal defensive use. I have documentation on that. It is HSCEMS-1212-00011, solicitation for the Immigration and Customs Enforcement Agency. Now, who needs an AR-15 with 30-round mags? That question has also been brought up. And I would like to put forward that had the Koreans in the LA riots not had AR-15s and AK-47s with 30-round magazines and Ruger 30s, their businesses would have been burned to the ground like all of the other businesses in their neighborhoods. Theirs stood because they stood their ground. I would also put forward the conjecture that had the 10,000 students at Tiananmen Square not been unarmed, things may not have resulted in so many of them disappearing. In your own laws, United States versus Miller, 309, U.S. 174, 1939, it was made clear that the type of firearms protected by the Second Amendment were those specifically useful and common for military use in defense of the state. I would like to note that the state is not the government. The state is the people. In Lewis,
excuse me, Mr. Ong, if you would.
In Lewis versus United States, 1980, it is stated that the Second Amendment guarantees no right to keep and bear a firearm that does not have some reasonable relationship to the preservation and efficiency of a well-regulated militia. It has nothing to do with hunting. The militia, as per the debates in the convention, shows plainly enough that it is composed of all males physically capable of acting in concert for common defense. And further, that ordinarily, when called for service, these men were expected to appear bearing arms supplied by themselves and of a kind in common use at the time. The AR-15 is the most common and popular rifle in America at this time.
Would you please wrap up?
I will wrap up. I would like to wrap up with a statement from Judge Andrew Kozinski in Silveria vs. Lockyer, 2003. My excellent colleagues have forgotten these bitter lessons of history. The prospect of tyranny may not grab the headlines the way vivid stories of gun crime usually do, but few saw the Third Reich coming until it was too late. The Second Amendment is a doomsday provision, one designed only for those exceptionally rare circumstances when all other rights have failed. A free people can only afford to make this mistake once.
Thank you.